And since, if I recollect, on a common platform, we had Justice Roshan Dalmi, Justice Shashi Kapoor, and Justice Shalini Phansalkar. Therefore, when it transpired that Justice Roshan Dalmi has written a book which is already doing well, that is decoding the child sexual abuse, we thought that why not have insights and peep into one of the takes given in that book. And since Justice Roshan Dalvi and they have been pivotal in building up Beyond Law CLC, I had requested Justice Roshan Dalvi at a late time that, ma'am, kindly give some introduction, though Justice Shalini as such doesn't require any introduction. But as they say that, in Hindi they say ek aur ek 11, and we thought that when two minds who are thinking on the same page, why not bring them? And that too, not on a page, but on a book, which Justice Shalini has written on decoding of the child sexual abuse. I will ask Justice Roshan Dalvi to say a few words, then we will ask Justice Shalini to give the insights of evidentiary standards in POCSO Act, which is slightly different from the other criminal jurisprudence. Over to you, Justice Roshan Dalvi. And we are enamored by the fact that you have accepted, even at the late budget you have agreed upon. Over to you, ma'am.
Okay. Good evening, friends. Good evening, Vikas, Shalini, and everyone. It is such a pleasure. It's a delight, really, to be with Shalini. We have worked together for the last so many years on this subject, the subject of gender as such. And this component of gender is Shalini's specialty. I'll just call her Shalini and nothing else.
Yes.
She has written a magnum opus on decoding child sexual abuse. And friends, you may be judges, lawyers, and law students, but decoding child sexual abuse is for everyone in our society, more especially youth. And when you are going to deal with any of these cases, of whom we call vulnerable witnesses, children are the most vulnerable of them all. And please always remember our constitution, the only constitution in the world which makes laws in favor of women and children. And this is one law in favor of children. This was long overdue. It was in so many countries that such a law had come. We were working on this law, Shalini as well as I, as sessions judges without that law. We were making it and we were trying to bring it into fruition. That was the time when Justice Shalini Joshi had written her thesis on this subject. That thesis ultimately became the book that you are now going to hear about. And it is her day. Whatever is in the book, it must come out of her. Only suffice to say it should be a Bible for anyone who practices in that sector. Thank you, friends, and over to Shalini.
Ma'am, I will just request Justice Shalini to just show the cover of the paper book, the cover of the book. Slightly closer, ma'am.
Up.
And
yes.
you will have to speak because then it's on the speaker view. Ma'am, Justice Shalini, the book. Yeah.
Thank you so much. Thank you so much, Justice Roshan Dalvi. It is such a pleasure to see you and to be with you in this session because we have, as you have rightly said, work on this together in that way. And thank you, Vikasji, also for providing this platform for holding the session on such an important topic of evidentiary standards in POSCO cases. Because POSCO cases are having its own peculiarities. POSCO Act itself deals with sexual abuse of the children, which is really the most traumatic, the most painful of all the offenses which are committed, maybe against another human being, and especially when such offenses are committed against the children who are vulnerable. The cause of their vulnerability is their innocence. It is their innocence which becomes their burden, their baggage. Not only because of their innocence, they become victims of abuse, and that too of sexual abuse, but that innocence also makes them vulnerable throughout the entire process of getting the justice. Maybe it is in investigation, maybe at the trial, or maybe thereafter also. And therefore, it is very important to understand the trauma which the child faces in such offenses. Naturally, these offenses are required to be treated differently as they are committed against the most vulnerable class of society. And another reason for treating these offenses differently and applying different evidentiary standards is that the child victim has to face two equations in our society, in our legal system. The first equation is child versus adult. Our entire criminal system, justice system, or maybe even civil justice system is adult oriented. It has no place as such for a child to come either as a witness or as a victim. The court, even anyone who has seen the court structure will know that it is a very formal structure where the judge is sitting on high pedestal, whereas the witnesses are in the witness box, accused behind, then defense counsel, public prosecutors, so many court staff. So it is a structure full with adult persons, and the child is for the first time coming face to face with this formal court structure. All our laws are also designed and implemented towards the adult. I mean, keeping adult in focus. Naturally, this equation is putting the child at unequal position. Another equation which the child has to face when it comes in the criminal justice system to seek justice, and that is as a victim, is is victim versus accused equation. Because just like our criminal justice system is accused oriented, similarly our justice system is adult oriented and accused oriented. All our laws are enacted to ensure that there is that the rights of the accused are protected to utmost security. Our constitution speaks of the rights of the accused, and our CRPC was totally silent till the word definition of victim was introduced in the year 2009, and thereafter we are talking of the rights of the victims. Naturally, in such a system, which is inherently unequal because of the two equations, using the same premise of equality or the Evidence Act, which is applicable, is bound to and going to result in some sort of injustice to the child. And therefore, it was thought fit that just a child in conflict with law requires different treatment in the trial process, investigation process, in disposition of such cases also. Similarly, when child comes as a victim, the child requires a special law, a special treatment, a special statute, and along with the statute and along with the child-friendly procedures for recording the evidence of the child, it is felt that here the evidentiary standards are also required to be somewhat different. And the main cause for the same was naturally the vulnerability of the child, the age of the child, which is so young, so innocent, hardly aware of his own anatomy, own body parts. And in such a case, when child has to give evidence of the sexual offense, that it is just impossible for a child to put in words what has actually happened, especially when child sexual abuse takes place in the privacy and secrecy. There can be no eyewitness to such incident. The only person who can depose about the same is the child. Whatever evidence of other witnesses at the most will be only corroborative or circumstantial. But the testimony of the child is the foundation or the sole piece of evidence on which the entire prosecution case is required to be tested. And so far a child is concerned, it is just impossible for the child to state everything that has happened. These offenses are also, of such a serious nature, but they are committed by the own family members or someone known to the child. The peculiarity of child sexual abuse is that the accused in such cases or the offender is not someone unknown, stranger to the child, but someone from the family itself, someone from the acquaintance, someone from the school, someone from the places which the child knows very well. Such persons who are like ordinary, normal persons, but who commit such sexual abuse, and when the child has to give evidence against such a person who is a family member, maybe a father, brother, cousin, uncle, or maybe a school teacher, sports teacher, rickshawala uncle, or maybe a neighbor or someone, family friend, then it is another ordeal for the child to give evidence. And that's why recording of evidence under the POSCO Act, we have incorporated, legislature has incorporated several innovative provisions considering the ordeal which the child faces in recording of the evidence, and which I have described in detail. And here I would really like to read from my book, because that will explain in exact words. At page number 184, I have, because I had the occasion to record and conduct the cases of child sexual abuse. I have conducted several of such cases, and I am really the witness to the trauma faced by the children when they come to give evidence before the court. And here I quote from my book: it becomes really an ordeal for the child to put in exact words what has happened, to find correct words for such an inarticulate child whose vocabulary is limited becomes a difficult task. The child does not know sexual organs of her own. What to say of the sexual organs of the accused? How she is to state that accused has put his penis in her private part, touched her, or kissed her? Her evidence that accused has done some dirty things to her is not sufficient. The accused and his counsel want to know what is her concept or notion of dirty things. After all, life of the accused depends on her testimony. Mere kissing or touching private part may amount to, from her perspective, a dirty things. But it is not an offense of rape, so they keep on probing further. Whether accused has removed her frock, whether he removed her underclothes, whose clothes were removed first, whether he fell her on ground, whether he kept her on lap, whether he inserted his finger, object, or private part, whether there was bleeding, discharge, emission, whether she shouted, whether she resisted, if yes, how. So many questions, so many suggestions. Child is bound to be bewildered, but not allowed to show even the sign of bewilderment. If it does, she becomes suspect. Little wavering on her part, and she is disbelieved in open court. What a traumatic experience. It is apart that since there is a wild gulf between the expressions of the child and the language of the courts, offenses also get minimized. There is also inordinate delay in recording evidence of such cases also. The special courts also at present being flooded with these cases. And in such situation, when the evidence of the child is the only piece on which the entire case rests, and when the child is having so many difficulties in giving evidence, and there is no other corroboration, how to go about it? And that's why the POSCO Act has made special provisions in the Act. It has introduced two presumptions, and which are of very significant importance because they have made inroads in the fundamental criminal jurisprudence. What our fundamental criminal jurisprudence states, that entire burden to prove the case lies on the prosecution. So even if accused doesn't open his mouth, in the entire case, it doesn't make difference to the outcome of the case because he is covered with the right of silence. However, as regards these offenses, understanding the vulnerabilities and the difficulties of the child, the two important presumptions are laid down, and those presumptions, which are those, for this purpose, Mr. Vikas, can I have the PowerPoint presentation? So we are having, because these two statutory provisions are important, and I would like to really quote them to understand them. Desktop one, can I share?
Yes, ma'am, it has been allowed to you.
Okay, okay. Is it visible?
No.
Okay, I will try again if it is possible. Share. It is share is there. Desktop one, or which one to share?
I couldn't get it, ma'am. What are you saying?
Desktop one, basic, advanced files, what to share? Open system preferences.
Just click it on the click where the screen sharing is shown.
That I'm doing, share screen. Then I'm going, but my Mac is giving option share. And then I share, it is showing open system preferences. And then it is
file
not,
open. Just open the file.
I have open, it is kept open on the desktop. But you are unable to see?
No.
Okay.
Or if what you can do is you can share it on the WhatsApp to me. I will post it.
Okay. So there are two provisions under the Act which are of importance. That is section 29. Till the time I share it, I will talk. So that is section 29. And another is 30. 29 talks about the presumption as to certain offenses, whereas 13 talk about the presumption as to culpable mental state. Just a minute, huh? Yes. Can I share it on, okay.
Or you can share it on the email.
Okay, I have, now I'm sharing it on WhatsApp. Let us
No
see.
issues. No issues.
Okay, you can, I have sent it.
I've
so,
received.
okay. So there are these two important provisions, as I said. The first is presumption, which is as to certain offenses. And this presumption, in my opinion, is really of a drastic nature. Because what this presumption says, where a person is prosecuted, I am emphasizing the word prosecuted, for committing or abetting or attempting to commit any offense under section 3, 5, 7 and section 9 of the Act, the special court shall presume that such person has committed or abated or attempted to commit the offense, as the case may be, unless the contrary is proved. So what this section directly implies is that the moment a person is prosecuted, the special court shall presume that he has committed an offense unless the contrary is proved. Now, what can be the significance of the word is prosecuted? When we call the person as prosecuted, when he is arrested, when charge sheet is filed, or when his charge is framed, or when the trial is conducted. In my considered opinion, having regard, next slide, having regard to
As and when you want the slide to be changed, just inform me. I will do it.
You have to change it now.
Yeah. No, otherwise, as and when you want that the slide should be changed, you just
please change it. Please change it. Next slide. Because it is the first slide, but I would like next slide. So, what is the significance of the word prosecuted? That is important. And as I said, whether when the charge sheet is filed, he is said to be prosecuted, or when the charge is framed, he is said to be prosecuted, or when, the trial is conducted, evidence is recorded, and at the time of recording 313 of CRPC, he is to be presumed, because here another word important is shall. So at which stage this presumption triggers or comes into effect is important, and what is the effect of this presumption. Plain reading of this section may feel that the moment accused is arrested or charge sheeted, this presumption will come into effect, because that is what normally we understand the word prosecuted. So does it mean that then the accused doesn't, a prosecution doesn't have to lead any evidence at all? Does it mean that merely on filing of charge sheet, the accused will be presumed, accused shall be presumed to be guilty, and then he will have to lead evidence to prove the contrary? So this is what sometimes I feel that legislature might have intended that also, having regard to the difficulty of the prosecution to prove the offense, because it is very difficult, and for the child also to give evidence. Child may commit several inconsistencies because of his age, because of her age, because of so many other factors like vocabulary being not limited, being overcome with the shame, trauma, embarrassment, and so many aspects. So that might have been the intention of the legislature, to spare the child the trauma of giving evidence, and it will be for the accused to prove that he is innocent the moment he is prosecuted. So these are the various angles which are, legislature, what legislature intended, we don't know, but we are having the interpretation of these section. Now, next section, which is also important, change the slide, please, is section 13. So first section talks of presumption coming into effect the moment accused is prosecuted. The second section 30 talks of the mental state of the accused. And there is a presumption which says that in any prosecution for any offense under this act, which requires a culpable mental state on the part of the accused, the special court shall presume the existence of such mental state, and it shall be the defense for the accused to prove that he had no such mental state with respect to the act charged as an offense in that prosecution. So this is a presumption as to culpable mental state. And why this is important? Because in case of subtle sexual offenses, like kissing, fondling, or disrobing the child, removing the clothes of the child, or showing the child pornography, it is very difficult for the child to state that accused has done this particular act with sexual intent. What evidence child is supposed to give on this aspect? It is also difficult for the prosecution to prove that accused was having such culpable mental state or he has done it with sexual intent. And hence, because child is unable to depose about the same, this presumption is laid down, which we will not find in the sexual offenses committed against the adult persons or against the adult woman. Because she can state, and when she states, it can be said. But so far a child is concerned, such subtle sexual offenses, which may not occur in respect of a woman, but they may occur. And therefore, this presumption is of importance, that moment such act is proved by the child or by the prosecution, that child was disrobed, child was kissed, child was fondled in their private parts or otherwise, then the burden will shift on the accused to prove that he had no such mental state, that is sexual intent, and whatever has happened, it was with pure, innocent way, and it has got nothing to do with sexual intent. Now, the legislature has made another inroad in the says, it is said that a fact in such cases will be said to be proved only when the special court believes it to exist beyond reasonable doubt, and not merely when its existence is established by a preponderance of probability. So normally in criminal jurisprudence, when certain burden is cast on the accused, he is not expected to prove it beyond reasonable doubt, to prove any fact. The burden on him is only preponderance of probability. But here, as per section 30 subclause 1, it is for the accused to prove the fact. And subclause 2 says that when he is to prove this fact, then he has to prove it beyond reasonable doubt. So the burden which is initially on the prosecution, now that burden to prove the mental fact, mental intent, sexual intent, or culpable mental state is now shifted entirely on the accused, and he has to do it beyond reasonable doubts. So these are somewhat two revolutionary provisions introduced in the act, and that is particularly in the context of the vulnerabilities of the child and difficulties for the prosecution to prove its case. Next slide, please. And then exactly when we say this pair of two presumptions, are they a radical shift from presumption of innocence to presumption of guilt? Because section 29 indirectly says that you are presumed guilty unless you prove to be innocent. Whereas we always in the criminal procedure, criminal jurisprudence, say accused is presumed to be innocent. So whether it is a radical shift and whether section 13 is in making the burden on the accused, putting the burden on the accused, and lightening the burden of the prosecution to prove certain facts only on preponderance of probability, and then the burden will shift on the accused. Next slide, please. Then there is also, so the basic question when we are talking about, the evidentiary standards in POSCO cases is whether these two provisions mean that prosecution need not adduce any evidence, as I said, because the moment he is prosecuted, presumption will trigger into. As there is already presumption that offense alleged is committed by the accused, and it will be for the accused to prove that he has not committed an offense, and he has to prove it beyond reasonable doubt. And for that purpose, we have to see how the law has developed. And next slide, please. And this talks about the specific purpose of the presumptions. Mr. Vikas, can you change the slide, please? Next slide, next. So, as I said, this is the normal rule that burden lies on the prosecution to prove beyond doubt, whereas on accused, normally on preponderance of probability, which he discharges through cross-examination or other material or in his statement under section 313 CRPC. Now, these two provisions are therefore popularly known as reverse burden of proof, because now they are casting the burden not on the prosecution, but on the accused. And why it is done? To balance the personal rights of accused with community's broader interest in law enforcement. And this is not the only act, though this act is drastically different, these two provisions, from the provisions in other act laying down certain presumption, and we are going to see them also comparatively. So next slide. Because here, when we want, as I said, the basic presumptions under criminal jurisprudence, accused is presumed to be innocent unless proved guilty, and entire burden of proof lies on the prosecution to prove the guilt of accused. Next, but sometimes this presumption is also having the exception in Evidence Act itself, like section 106, where the facts are especially within the knowledge of the accused. The burden is on him to prove those facts. But here also the initial burden is on the prosecution to prove the charge. It may be a case of plea of alibi also, where the burden shifts on the accused. So there are certain exceptions in the form of presumptions under Evidence Act also. We are seeing how these presumptions under the POSCO Act are different from the presumptions laid down in Evidence Act and other act. So next slide. And that is like, under NDPS Act, we have section 35, which lays down a presumption that when a person is found in possession of narcotropic substance, it will be presumed. Similarly, that possession is conscious possession, We also know Section 139 of Negotiable Instruments Act. When the check is issued, it will be presumed that it was issued toward discharge of legal liability. And several such presumptions are there. But these presumptions necessarily contemplate the burden on the prosecution to prove certain facts. Like Section 35 contemplate the burden on prosecution to prove that accused was found in possession of narcotic substance. So physical act of possession is required to be proved. Then only the consciousness of possession will be inferred. In Negotiable Instruments Act also, physical act of delivering the check, handing over the check is required to be proved. Then only the presumption will arise that it was issued towards discharge of legal debt. Whereas in the presumption under Section 29, no such physical act or particular act is required to be proved by the prosecution as per Section 29. It directly says that when he is prosecuted, it shall be presumed. It doesn't say that first a child has to prove that the act has happened, then only it will be presumed. Nothing like that. So that is a fundamental difference. And why this difference? Next slide, please. We will have to see with the help of the understanding. I mean, why the presumptions are important, why this necessity of presumption, because there is a difficulty on the prosecution in proving certain facts, like we have seen under 106 of Evidence Act. If certain facts are within the knowledge, exclusive knowledge of the accused, prosecution will not know. So hence prosecution cannot be asked to do impossible. And therefore, to plug the loopholes and gaps in evidence and to get best possible evidence, such presumptions are laid down. Because Section 29 and 30 presumptions are to be looked from this angle. Next slide, having regard to the difficulty which prosecution face, next slide, because there are certain presumptions, and as we all know, Section 4 may presume, shall presume, conclusive proof, and these presumptions, where they fall, that we will see. Next slide. Next slide. Presumptions of facts are inferences from certain facts pattern drawn from the experience and observation of the common course of nature, whereas Section 114 of Evidence Act talks about discretionary presumption, because the word used is may. Whereas in POCSO Act, in both these provisions, the word used is shall. Therefore, these presumptions are in that way mandatory. Next slide. So mandatory presumptions and goes as far as to shift the legal burden, and that is what we have seen in both these presumptions. Next slide. But basic difference, I mean, though we say that the moment accused is prosecuted, the presumption will come into picture. But then what is presumption? If we understand that, then it will be easier to understand why this provision is interpreted in a different way. So presumption in itself, not evidence, but only rule of evidence, making a prima facie case for the party in whose favor it exists, and indicating the person on whom the burden of proof lies. So presumption doesn't mean evidence. Hence, when Section 29 says that when the accused is prosecuted, it shall be presumed that he has committed the offense. It is not an evidence as such. And therefore, it is interpreted in a way to say that the burden on the prosecution still remains to prove the essential ingredients of the offense. And that we will see with the help of the case laws. Next slide. I mean, this presumption to some extent can be comparable to Section 113A of Evidence Act, wherein there is presumption as to abatement to suicide on the basis of prosecution proving certain facts. Like during 7 years from the date of marriage, the married woman has committed suicide, and it is proved that during this period she was subjected to harassment, willful conduct, torture, etc. then the presumption will arise that if that she has committed suicide on account of such torture, or presumption of dowry death, when on proof of certain facts, the presumption will be drawn. Like 114A also, absence of consent. Here the initial burden on prosecution, only on proof of certain facts, onus shifts on the accused. But as I said, 29 doesn't talk of these things. Section 29 simpliciter says that when accused is prosecuted, so the real significant word is, what do you understand by the mean prosecuted? Prosecuted means prosecution has to prove certain facts, prosecution has to lead evidence, then only presumption will arise. Because in 113A, 113B or 114A, initial burden is definitely let down on the prosecution in the section itself. But section 29 is not laying down that burden at all, is not talking of that burden at all. But then the next slide, please. As such, the question therefore arising is whether accused can be convicted on the basis of presumption alone. And then various high courts have held, next slide, that it is not so. Next slide, please. That is presumption, yes. When the facts give rise to a presumption of law, the prosecution shall be taken to have discharged its obligation to prove its case beyond doubt, reasonable doubt. In such a case, the onus shifts to the accused to prove the contrary. What is of immense importance to note is that while a presumption of fact can be rebutted by an accused by offering an explanation which is reasonable and plausible, a presumption of law cannot be discharged by explanation alone. What must be proved is that the explanation is true. And in that context, next slide, section 29 is required to be considered, because Supreme Court has again and again said, even in this judgment of Narayan Gautel, so presumptions are not evidence but rule of evidence. They are there to fill the gap and to be used by the court in the course of administration of justice to remove lacuna in the chain of direct evidence. Next slide. And in case of child, we have seen what is the necessity of presumption to take care of child who has limited capacities and capabilities of appreciation and understanding mental state of others and even of herself, to lighten the burden and vulnerabilities of already vulnerable child, to ensure proper and smooth implementation of the act to achieve its object of protection of children. So these presumptions are introduced in the act with a very laudable object to ensure that child doesn't have to say anything, but still then it will be presumed that accused has committed the offense with this particular culpable mental state. Next slide. Next slide, please. We will go to another, next slide, because this pertains to 35 and we may not have to, whether these two provisions, which are totally shifting, radically revolutionary change in the criminal jurisprudence, whether they can be called as constitutionally valid. And that as a question is still not raised before any High Court or the Supreme Court. But that question was for consideration in the case of, Section 35U of NDPS Act, in the judgment of Noor Aga, because as I said, under Section 35U of NDPS Act also, the question arose whether the presumption of conscious possession, which is raised under that section, is against the fundamental principle of presumption of innocence of the accused. And the Supreme Court has held that presumption of innocence is human right, but it is not equated to fundamental right and liberty. It must be subject to certain restrictions. Enforcement of law and protection of citizens need to be balanced. It must be tested on the anvil of state's responsibility to protect its innocent citizens. And therefore, Supreme Court had upheld the validity of Section 35U of NDPS Act. Here also the presumptions are introduced, to protect the innocent citizens, the most vulnerable class of the society, that is the children. And therefore, there is every likelihood that the constitutional validity of these two presumptions will be definitely upheld. And it is so because of another reason also. And that is next slide, because the way, next slide, it has been interpreted. I mean, Bombay High Court has said that presumption under Section 29 is different from the general jurisprudential practice under CRPC, that the prosecution is to prove allegation against the accused, and if it fails, then the accused is not required to show his innocence. So basically, it is making a difference because this is the general presumption. Next slide. But now, if the prosecution succeeds to prove the guilt of the accused, as per Section 29 of the Act, even in that case, accused is asked if he can rebut the prosecution case through his defense evidence. And therefore, it is conjoint happening of two events. First, prosecution succeeding to prove the guilt of the accused, and secondly, accused failing to rebut the veracity of prosecution case, that he is called to face the punishment. And therefore, the burden on the prosecution to lead evidence is not yet, gone away or washed away. That burden still remains. Next slide. Then this is the interpretation of the next slide. As regards Section 30, in its ultimate effect, child is required just to give the account of physical act of the accused. This account has to stand the test of proof beyond reasonable doubt. Once this test is complete, the statute would fill the required mens rea in the alleged act, and then it will be for the accused to disprove culpable mental act. Accused can prove that child has misunderstood or misinterpreted his good acts. So that is entire import of Section 30. So the physical act, still the burden on the prosecution to prove. And then it was not with culpable mental state, that it will be the burden on the accused. That is as regards Section 30 of the Act. Next slide. As regards 29, I mean, which is really the most complex provision, because it is not, the legislature intent might be different, but the way it is interpreted might be different. Because as I said, legislature did not want child to, maybe child to give the evidence, because giving evidence is again a trauma, secondary victimization, re-victimization. And therefore, the moment the case accused is prosecuted, it was said that it will be presumed. But now various high courts have interpreted it in a different way. It is said that proper interpretation of Section 29 is that prosecution is absolved from proving its case beyond reasonable doubt, but is only required to lead evidence to establish ingredients of offense on a preponderance of probability. So the burden is lightened, burden is reduced. Only when prosecution lays foundation of its case by leading cogent and reliable evidence, though in a shift on the accused, to prove the contrary. If the prosecution fails to do so, no question arises of invoking Section 29. So this section now 29 is interpreted like Section 113A, 113B of Evidence Act, where certain facts are required to be proved by prosecution, then only the burden will shift. But Section 29, if we read and we have read, it doesn't say so that certain facts are required to be proved. It says prosecuted. Now, what is prosecuted? It has been interpreted in such a way that as if accused is tried, prosecution has already laid evidence, and thereafter only the burden will shift on the accused. And why it is done so? Because according to Calcutta High Court, if any other interpretation by holding that prosecuted is as good as filing of charge sheet and then the burden will shift, that would lead to absurdity and render the section constitutionally suspect. And therefore, it has to be interpreted that prosecution has to prove the basic facts, maybe not beyond reasonable doubt, maybe only on preponderance of probability, but once the prosecution proves it, the burden will on the accused. Next, otherwise there will be no burden on the accused at all. And this is what is reiterated by Bombay High Court again, that submission that statutory presumption under section 29 is absolute must be rejected, because it is not an absolute presumption. If the suggestion is that even if foundational facts are not established, the prosecution can invoke the statutory presumption, such an interpretation of section would render the said provision vulnerable to the vice of unconstitutionality. So ultimately, this presumption, next slide, is, section under section 29 is, read like any other presumption under the Evidence Act or any other presumption under any other law also. Though the basic, intent might have been different, but if it was interpreted in that way, it would have been constitutionally void. And that is what again and again it is said that when it would stand activated, as I said, prosecuted. What does prosecuted means? So whether immediately after charge sheet is filed, and that is what the Bombay Court says, the statutory presumption would stand activated only if the prosecution proves the foundational facts. That is, that the incident has happened, it was proved. And even if the statutory presumption is activated, the burden on the accused is not to rebut the presumption beyond reasonable doubt. Suffice it if the accused is in a position to create a serious doubt about veracity of the prosecution case, or the accused bring on record material to render the prosecution version highly improbable. So, 113, 113B, the similarly 29 and 30 are now being interpreted, though the legislature intent might be different. Next slide, please. That is what again and again they are saying, it will operate only upon prosecution proving fundamental facts, foundational facts. Unless the prosecution is able to prove those facts, the presumption would not operate against the accused. Next slide. Even if the prosecution establishes such facts and the presumption is raised against the accused, he can again rebut the same either by discrediting the prosecution witnesses through cross-examination or otherwise. But if you see section 30 of the POCSO Act, the mental state, accused has to prove, burden of proving the contrary on the accused, and that fact he has to prove beyond reasonable doubt. That is what section 30 subclause 2 says. 29 says on mere prosecution. But then if it was interpreted that like that, then it would have been constitutionally void, and therefore the various high courts have taken care to ensure, next slide, that it is interpreted in such a way that it does not become constitutionally suspect. Now the question again is when this presumption will be arising, at the stage of bail or otherwise, because at the stage of bail also, the prosecution has tried to rely upon this presumption, saying that accused is not presumed to be innocent in such cases, but he is presumed to be guilty and the burden lies on him to prove the innocence. And therefore, bail should not be granted. There are two, contrary views. According to one view, yes, that presumption will operate at the stage of deciding bail application also. Whereas another view is that, no, that will not operate. But if the charge is framed, again, the things will be different. So in this case of Karnataka, it was held that it was a case of romantic relationship. And it was argued that in view of this presumption, the accused accused is not entitled to bail. And it was held that it cannot be said that there can be any presumption of forcible acts on the part of the petitioner, only if the minority of the girl is established. then the letter of law will have to be applied till such time to proceed on the presumption that girl was a minor and to incarcerate the petitioner virtually punish him. And therefore, the presumption was not invoked at the time of deciding bail application. Next slide. Whereas, Karnataka High Court has taken this view. Next slide. But other high courts, you will see, Kerala High Court has said that this presumption will have to be taken into consideration. It was held that having regard to the presumption laid down in section 29 of the Act, the innocence of the accused cannot be presumed, and therefore his bail application came to be rejected. Next slide. So there are still at present, next, close. There is different views. Supreme Court has yet to pronounce its views as regards these two presumptions which talk of a reverse burden of proof. What do we understand by reverse burden of proof, and how they have made inroads into the fundamental principles of criminal jurisprudence, and why it was the necessity to make such inroads. Especially, in case of children, it is often said that they are the most dangerous class of witnesses because they are susceptible to tutoring. They live in the make-believe world, and these are the quotation, words which I am reproducing are from the judgments of the Supreme Court. So when the children are, considered to be the most susceptible to tutoring, considered to be most, who can be, just give evidence in the make-believe world. In such cases, to discard their evidence after recording it is very traumatic. And therefore, these two special provisions were laid down by the legislature to ensure that the evidence of child might not be required to be recorded at all. And then on the basis of such presumption, the guilt of the accused can be proved. For example, if the medical evidence is very clinching, like there is injuries to the private part of the child, to the private part of the accused, where is the necessity of child again undergoing the trauma of giving evidence in the court? If the identification of the accused is as the same person is proved through the medical evidence, through the forensic evidence like DNA, or through the evidence of some witness who has seen the accused leaving that place, that may be, the reason why the prosecution has failed, that if it is so traumatic for the child because of its incapabilities, because of its innocence, because of its vulnerabilities to give evidence, why not dispense with the evidence of such child and cast the burden on the accused himself to prove his innocence? But having regard to, Limit Committee has also tried to make inroads in our system of criminal jurisprudence. This act has also tried to make inroads, but having regard to the drastic punishment provided under the act, if the offense is proved, the high courts and judiciary is rightly interpreting the same in a balanced way to ensure that the presumption will help the prosecution to fill up the lacuna, but it will not obviate the necessity of leading the evidence. But while appreciating the evidence in such cases, we have to remember that here child is not a witness, child is a victim as such. When he comes merely as a witness, calling the child as a dangerous class of witness, or calling the child as being tutored or living in make-believe world may be okay, but when child is coming as a victim, and which child can imagine or conjure up sexual abuse, which is the most heinous of all crimes, most traumatic, has happened. So here the child's evidence is required to be relied upon, to be believed upon. Otherwise, also in sexual offenses against the adult woman, also we are saying that her sole testimony is sufficient. Calling upon corroboration, insisting on corroboration is adding insult to her injury. Here also the same situation and more accentuated, because here the person against whom the offense committed, the victim is a child who, who is beyond, conjuring up or imagining such incident or being tutored to give such evidence and being able to give the evidence. And therefore, apart from issuing various guidelines under the Act itself as to how to record the evidence, and despite that, as the vulnerabilities of child continue to remain because of inarticulateness, limited vocabulary, not knowing the words, also sex being a taboo subject and adding trauma to the child. Here, the evidence of the child is required to be relied upon, especially in the light of these two presumptions, which depict the intent of the legislature. That nothing, now we are shifting the burden on the accused. So evidentiary standard under the special legislation is required to be considered as a different one, having regard to the different characteristics of the victim, of the offense, and the nature of the offense. That's all I think we can. I'm ready, open to ask any question. And I would like really Justice Roshan to add something.
Ma'am, there's one question. Whether directions issued by the Honorable Supreme Court in the case of Ardmesh Kumar are applicable to the offences under the POCSO Act, having punishment up to 7 years. One view is that POCSO being a special act, these directions are not applicable. Considering the inconsistent interpretation of Section 29 of the High Court, shall not the Supreme Court come forward to put forth its interpretation to be guiding force for the other judgments?
Definitely. Supreme Court should do it. No question about it. But Supreme Court should have occasion also to do it. Some case should be raised before the Supreme Court. Someone should approach the Supreme Court. And basically, as regards Section 29, as I said, the interpretation of 2-3 High Courts is same. That burden on the prosecution to prove the foundational facts remain. Then the onus will shift on the accused. As regards at which stage, whether at the stage of bail, it will be activated or not, that on that aspect there are inconsistent views, and maybe it will reach up to it may reach up to the Supreme Court.
This is by Advocate Sunil. Whether prosecution can file the summary in a POCSO matters.
The question is whether such offenses are compoundable. No. So question doesn't, the summary cannot be filed as such. These offenses are not compoundable.
Then what is the difference between, I suppose he wants to simplicity, ask between a reasonable doubt and a preponderance of probability, because he says between doubt and beyond reasonable doubt.
He exactly mean what he wants to ask. Between doubt may be imaginary also, doubt may be something not a beyond reasonable doubt is having a standard of its own, high standard, where lingering doubt is not sufficient, beyond reasonable doubt. So that is calling for higher standard of proof, not simplicity proof, proving by
beyond shadow of doubt.
Yes.
What we say beyond shadow of doubt.
Yes, beyond shadow of doubt. And Supreme Court has explained these terms in various of its judgments. And some of the judgments I have also quoted in my, recited and given reproduced in my book also.
You can show the cover of the book again.
Yes.
So that, those who have joined late.
Yes.
Yeah, the book's name is Decoding of Child Sexual Abuse. Justice Shalini had just, this book was recently launched around a month ago, ma'am.
It is having the foreword written by Honorable Justice D.Y. Chandrachud, Judge, Supreme Court of India. It was launched at the hands of Honorable Justice A.S. Oak, Judge, Supreme Court of India, on 22nd January 2022. So just last month, 3 weeks back, it is launched.
Yes, those who have who wants to have more insights, ma'am has carried a wide spectrum, and the index she had shared, it covers a wide spectrum. I can say that it's what Justice Roshan Dalvi said, it's a Bible you can understand, or what we say that is the Magna Carta to understand the POCSO Act. So those who want, they can buy the book. It's available on the links on the different platforms, maybe in Amazon, etc., and also on the law vendors. Over to you, Justice Roshan Dalvi.
Oh, friends, there is very little to add here, except that so far as the presumption is concerned, I always say that we have to consider this presumption alongside the conviction. There is no conviction. There is only a presumption that has to be made. And because there was so much clamor that children's cases cannot be proved beyond reasonable doubt because of various factors which Dr. Shalini Joshi has told you about, that therefore there is legislation. There is only presumption. Once there is presumption, it can be rebutted. It has to be rebutted in a particular way. Now, there are two presumptions, one of these facts, one of the mental state, and that would require complete proof beyond reasonable doubt. So you can't say, I was just here, therefore I was not there, and therefore there is preponderance of probability. No, that will not do. And that has to be because you cannot water down a new legislation which has come up by just this kind of interpretation. And therefore, it's made very clear that it is not on preponderance of probability. Otherwise, in other cases, we do acquit on preponderance of probability also. That is really for the presumption aspect. I will not go into other aspects because Shalini has not gone into other aspects.
Yeah.
Because we wanted to concentrate on the
Yes, correct. That is the
special-
theme today
yes, what is the peculiarity of
this.
We just wanted to funnel it on one particular point,
yes,
which deciphers it from the other part.
right.
The intent was.
Which distinguishes
Correct.
this act from other.
Absolutely.
Yeah. The question is, if the male child has committed a sexual offense against a female child, whether POCSO Act will be applicable in such case, or whether he's required to be produced before the JJ board.
It is POSCO Act, under it is a gender inclusive or gender neutral. So the word person defined under the act, is any person below the age of child. The child is defined under section 2 to mean any person below the age of 18 years. So naturally, whether that person is a male or female, he can be a victim. If he is a victim, and if he or she is a victim, male child, if the sexual offense is committed, he will be a victim and will come under the POSCO Act. Now, if the abuser is a female and she is also below the age of 18 years, then she will go before Juvenile Justice Act. But if she is a major, then the case will be tried before the special court under the POSCO Act. So gender inclusive definition of child means male child can also be subject to the sexual abuse.
Last question, if victim is mentally not matured, can it come within the ambit of this act?
Yes, that is really a good question because, mental age is not considered under the act. What is considered is the physical or biological age. And that is how the Supreme Court has interpreted it in the judgment of ERA, which is of 2017 or 18, and which I have quoted in my book also. Supreme Court has said that legislature has never intended to cover the mental age. So in that case, the victim was 35 years of physical age, but her mental age was 6 years only. And that fact was not disputed. But then the Supreme Court says that the legislature has not used the word mental age. When legislature has said person below the age of 18 years, it means physical age, and therefore a person or a child victim mentally below 18 years not coming under the POSCO Act. She will have to go before the regular court. And that is a travesty because, really she needs the protection. Right. The victim of mental age, is the most vulnerable, and that person needs the protection under the act. But unfortunately, Supreme Court has called upon the legislature to take the call, and legislature has still not made any changes in the act. So judgment of ERA is on this point. Supreme Court has dealt with that judgment.
Right.
And the judgment citation is to ERA versus State of NCT Delhi, 2017. volume number 15, Supreme Court cases, page 133. So 2017, volume 15, Supreme Court cases 133. And I have dealt it on page number 318 of my book. So that aspect is really worth considering.
May I say?
Yes.
Now the Supreme Court has passed some directions for creating infrastructure as well as sensitivity in the entire justice system for vulnerable witnesses.
Yes.
And that is now going to be done under the aegis of Justice
Geeta
Mittal. So this kind of a witness, and especially a victim witness, would be then covered. So whether she goes into the POCSO court, as we call it, POCSO, or whether she goes into the same court as are all criminal courts, but gets good sensitive treatment, it will not make any difference. It's going into this building or that building, but she will get all that protection.
But even then, as regards the compensation, as regards support person, as regards legal assistance, so many features, POSCO Act is having, like interim compensation. I mean, and other assistance of so many other persons, agencies.
But that can be molded up to a point. It can be molded, you can always allow
to do a lot of.
That is the captain of his or her court. And therefore, she can say, well, this is a vulnerable witness and I'm going to have that. And we will be having now guidelines for all vulnerable witnesses, especially the mentally handicapped, physically handicapped, all of them would be vulnerable. Children form a class, but others are also vulnerable witnesses.
So those who have been connected on this platform, we have shared the index of the book. They can have the insight that what the book actually contains. As they say, it is just like a trailer of the movie. You can have the insights, what can it be there. So thank you, Justice Roshan Dalvi, for giving your, not only the introduction, conclusion and the insights. As they say, two heads are always better than one. And it was
always a better head.
Not at all. I would say two heads are better than one because the combination of two.
I am saying so.
And especially,
I have great respect for her. The way she.
Especially, I've seen on this platform that whenever you two come, then the magic of speaking improves. Thank you, Justice Shalini, for taking out the time and sharing the important facets under the POCSO Act, and Justice Roshan Dalvi also. Thank you, everyone. Stay safe and stay blessed.
All the best.
And on Wednesday, we will be having a session on emerging trends on the arbitration by Justice J.R. Midha, former judge of Delhi High Court. So do stay connected with us at 4:20. Thank you.
Thank you so much. Thank you.